Good afternoon, everybody. My name is Kathy Bennett. I've been at Bond now for 18 years and have been practicing in the environmental practice group for all 18 of those years. SEQRA is one of my very favorite topics, both to practice in and to talk about. So we've got a lot to try and cover in an hour, but we'll move through it as quickly as we can here. I thought this would be a good topic because, you know, SEQRA is something that all agencies have to go through, and so it's always good if you're familiar with it to get a little refresher, and if you're not familiar with it, then to become more familiar with it. And also the DEC is in the process of updating the regulations. There is some hope that those will be done by the end of the year, but we'll see how long that process takes. So at the end, I'll touch upon some of the changes that we might see in the coming months with respect to SEQRA. So just by way of introduction, these are some of the topics we're going to talk about today: classification of actions, how to coordinate review, making your determination of significance, if you issue a DEC or a positive declaration, going through the environmental impact statement process, and then a couple of special issues that are worth mentioning, and then discuss the proposed amendments. So here, you know, where is SEQRA found? Article 8 of the New York Environmental Conservation Law established the statutory framework for SEQRA. The DEC adopted regulations that are found at Part 617 of Title 6 of the New York Codes, Rules, and Regs. SEQRA is also found in judicial decisions, and there are thousands of judicial decisions that aren't always consistent on a wide array of SEQRA issues. And then the DEC has guidance documents available. Their two main guidance documents dealing with SEQRA are the handbook and then the workbooks that they just came out with in 2012-13 in terms of how to prepare the new short and long environmental assessment forms. There is also other guidance available in addition to the handbook and workbooks on the DEC webpage. So briefly, an overview of SEQRA. SEQRA is an additional layer of review. It's triggered when a state or local agency makes a discretionary decision. It requires that the agency consider environmental factors as part of its decision-making process, and it wants the agency to do this at the earliest possible time in that process. What SEQRA doesn't require is that your determination with respect to environmental impacts controls your decision. It just means that the environmental impacts have to be balanced with social and economic factors. So you can't just pay lip service to it. You have to take a substantive, hard look, and we'll talk about that a few slides from now, at the environmental impacts. SEQRA requires that significant and adverse environmental impacts be mitigated, and the SEQRA process must be completed before the agency makes a decision by which it commits itself to a definite course of future action. So here's where an agency needs to be mindful of its preliminary decisions that may not really be preliminary when it comes to the SEQRA process. So for example, entering into contracts to acquire land or to perform certain work may commit the agency to a definite course of future action that would require SEQRA to be completed before those agreements were entered into. And then scheduling a referendum or a budget vote would also be a decision that commits an agency to a definite course of future action. So if you're a school district, you have to complete your SEQRA process before you schedule your referendum. And so the golden rule of SEQRA that I like to remind people of is just this. No agency involved in an action may undertake, fund, or approve the action until it has complied with the provisions of SEQRA. What is the purpose of SEQRA? Well, SEQRA has substantive and procedural requirements, and the substantive procedures we talked about during the overview. But here they are again. To consider and weigh environmental impacts together with social and economic factors, make a determination whether the action may or will not have a significant adverse impact on the environment. And then agencies must avoid or minimize any adverse environmental impacts to the maximum extent practicable. And then the procedural requirements basically are in place so that the process is open and so that the public is involved and notified. So you have to document your results. You have to prepare most of your determinations in writing. There are filing, distribution, and publication requirements. And then SEQRA also establishes specific time periods for certain activities, but most of those time periods can be extended by agreement with the applicant for the project. So just some essential definitions as we start to get more into the process here. An agency is any state or local agency. So that can be a county, it can be an authority, it can be any town or village, it can be a school district. I will note, since I understand that there are some people from some colleges and universities on the phone, that colleges and universities, unless it's a college or university affiliated with the SUNY system, so SUNY ESF would be an agency. Syracuse University, Colgate University would not be agencies that are subject to SEQRA. So there might be some instances, and I've been involved in a couple of them, when a college can undertake a project without having to undergo a SEQRA review. It's not typical, but if a college is undertaking a project on their campus, that project does not require any local approvals other than, say, a building permit, so it doesn't need any zoning approvals like a site plan or a special permit. And if there is no public funding involved, then the possibility exists that the college can proceed with that project without having to go through SEQRA. So I just wanted to mention that because I knew we had some college and university folks on the line, and I have seen that question come up a couple of times now. So I wanted to make mention of that. And then once you're an agency who's subject to SEQRA, then we have to look at which kind of agency are you in terms of the SEQRA review process. So you have involved agencies. An involved agency is an agency that actually has to make a discretionary decision with respect to the project. So it's an agency that's either going to fund the project, an agency that's going to approve the project, or an agency that's undertaking the project or the action. That's an involved agency. An interested agency is an agency that does not have any approvals to issue with respect to that project or that action, but they want to be involved in the process. So for example, something's happening in a town and the neighboring town may want to be an interested agency in that process if the project is close to the municipal boundary line. So that's an example of what an interested agency would be. The lead agency, it's always going to be an involved agency. So an interested agency can never be a lead agency. The lead agency, and we'll talk a little bit more about the lead agency when we get into coordination. but the lead agency is the involved agency that's principally responsible for funding, approving, or undertaking an action. And so it's going to be that agency that then becomes responsible for making a determination of significance. And if the review is coordinated, which we'll talk about in a few slides, then that determination will be binding on all of the other involved agencies. So we'll explore responsibilities of a lead agency as we get into the process here. And then the definition of environment, it's a broad definition. It includes community or neighborhood character and human health, in addition to, you know, those areas of nature that we think, that we're more inclined to think of when we think of environment. So, you know, what we might always think of is impacts to air, impacts to water, impacts to historic resources. What we may not always think of are patterns of population concentration, distribution, or growth in an area, existing community or neighborhood character. So it is a broad definition. And then finally, the definition of action. So an action can be three things under the SEQRA definitions. It's a project or physical activity that may affect the environment, that's directly undertaken, funded, or improved by an agency. It can also be agency planning and policy-making activities that may affect the environment and that commit the agency to a definite course of future decisions. And then an action also includes the adoption of agency rules, regulations, and procedures that may affect the environment. And then I like to look at SEQRA as kind of a 9-step process, but really there are a lot of sub-steps along the way. But this is sort of an overview of the process. So you'll classify the action, complete environmental assessment forms, coordinate review, make a determination of significance. Depending on what your determination of significance is, you might be done there. But if you issue what's called a positive declaration, you'll continue with the rest of the steps, which means you may or may not conduct scoping. Right now that's optional. Review and accept your environmental impact statements. Maybe hold a public hearing. Definitely have a public comment period. Prepare finding statements, and then prepare and submit all required notices and filings. So the first step is obviously to determine whether what you're doing is an action that's subject to SEQRA. And these are just some examples of actions that are subject to SEQRA. More often than not, if you're a state or local agency and you want to do something, it's likely to be an action that's subject to SEQRA. It includes physical construction, acquisition of real property, establishment of districts, applications for grants, capital improvement projects, contracts, planning, adoption of laws, land use approvals, any combinations of these. And then the next step is to classify that action. And this can be an action that the agency is undertaking, or the action that an applicant is applying to the agency for some kind of approval or funding. So the agency looks at the action that it's being asked to undertake, and then it needs to decide whether that action is a type 1, a type 2, or an unlisted action. And type 1 actions are established in the SEQRA regulations as actions that are more likely to have a significant adverse impact on the environment and thereby requiring the preparation of an environmental impact statement. Again, that's just a presumption. That's not to say that everything that's type 1 automatically requires an EIS. It's just a presumption. It can be overcome by documentation and evidence And we'll talk about that. Type 1 actions are the big things. They're specifically listed, and they include activities or actions such as a physical alteration of 10 or more acres for new facilities, or of 5 or more acres for an expansion of an existing facility, construction of a new facility with more than 100,000 square feet, or expansion of existing facilities by more than 50,000 square feet. And then sometimes unlisted actions can also become type 1 actions if they're near certain types of important features, such as sites that are listed on the national or state registers, agricultural districts, and municipal parkland. Type 1 actions, the environmental review process has to be coordinated with all of the other involved agencies, and the applicant, or if it's the agency that's undertaking the project, must use the full environmental assessment form. Type 2 actions are the little things. They are specifically listed in the regulations, and they have been determined not to have a significant impact on the environment and require no further review. So if you determine that your action is type 2, you're done. You don't need to do anything else. What I like to tell agencies in this situation, though, is if you have a type 2 action, make a record of it. Make some kind of documentation. Have the board pass a resolution acknowledging that it's a type 2 action. It's better to have something in the record so that if there is a question later, or if there is a challenge or a lawsuit later, you have the support to demonstrate why you felt that action was a type 2 action that was not subject to environmental review. If it's a type 2, it's always a type 2, and we'll talk about that and what that means a little later on. And then next we have unlisted actions, which is neither type 1 nor type 2. So it's basically everything in between. And for these actions, coordination is permitted, not mandatory, but we do typically recommend coordination for unlisted actions as well. Unlisted actions, you can use the full environmental assessment form or the short environmental assessment form, and which form you use will really depend on the project and the size of the project. For larger unlisted actions, it may be more beneficial to use a full environmental assessment form instead of the short environmental assessment form. So what I call step 3, but it may also be step 1, depending on who the project sponsor or the applicant is completion of part 1 of the environmental assessment form. So when the agency is the project sponsor, the agency will complete part 1 of the form. If it's a private entity, then the private entity, as the applicant, will prepare part 1 of the environmental assessment form. And part 1 contains the site and project descriptions. When the forms were revised in 2012, DEC also at that time prepared a mapper and workbooks to help with the preparation of not just part 1, but all parts of the form. And so the project sponsor or its consultant can use that DEC mapper to help fill in part 1 of the EAF. And again, there are 3 main classes of information that the part 1 will provide: site description, project description, any zoning and planning information, and it kind of gets into, any other potential areas for impacts: waste disposal, traffic, whether the project will involve the filling of wetlands. So it starts to look at, especially if you use the long form, to look at what environmental impacts may be associated with the project. It may be useful, although it is not necessary, to attach additional information to Part 1 of your environmental assessment form. And this additional information could include maps, site plans, any studies prepared by engineers or consultants, any resources from other agencies. And the reason for this is a lot of times, especially if you're an agency that's undertaking the project, or even if you're an agency that's working with an applicant and you're in favor of the project, you want to get to a negative declaration, and you really believe the project should be neg decked, which is finding that there are no significant adverse impacts associated with the project. But in order to get to that determination, you as the agency may require more information or more documentation up front to support that conclusion that the project will not result in any significant adverse environmental impacts. So I've seen a lot of really large projects neg decked because the information that the agency presented or the information that the applicant came in with was so substantial that it allowed the reviewing agency to take that hard look that's required by SEQRA and determine that there would be no significant adverse environmental impacts. So keep that in mind when preparing Part 1 of the environmental assessment form. And then I've already mentioned the two forms. There's the full environmental assessment form, which is required for a Type 1, optional for an unlisted. There's the short environmental assessment form, which I think is 4 pages, and that's frequently used for an unlisted action, but it cannot be used for a Type 1 action. So you've heard me mention coordination a couple of times. Let's talk a little bit about what is coordination and when it's required. Coordinated review is a single integrated environmental review of a proposed action. In other words, it's the process by which involved agencies cooperate to complete the environmental review process. And under a coordinated review, one agency, known as the lead agency, manages the environmental review of the project. Once selected as lead agency, that responsibility lasts until the SEQRA process is complete. And the lead agency may not assign or delegate its review authorities to another entity. Coordinated review is required for all Type 1 actions and is recommended, but not required for unlisted actions. For unlisted actions, whether to coordinate or not is really a judgment call. If the environmental review is uncoordinated, then each involved agency will review the environmental impacts of the project independently. However, if any involved agency identifies a significant adverse impact that requires the preparation of an environmental impact statement, then the uncoordinated review process ends, and that agency must initiate a coordinated review process. So that is a reason to always consider coordinating review, even for unlisted actions. benefits to coordination: one agency is running the show. Interests and concerns of all involved agencies are considered and weighed by the lead agency in the determination of significance. And then that determination of significance, either the negative declaration or the positive declaration, binds all of the other involved agencies. So how does coordination work? Typically, one of the involved agencies, and it can either be the agency undertaking the project, or if there's a private applicant involved, then it tends to be the agency receiving the initial application or initial request for approval or funding, will send out letters stating its intent to act as lead agency in connection with review of the project. And once those letters are sent, all of the other involved agencies have 30 days in which to object or consent to the designation of lead agency. So if you want this process to be less than 30 days, then an agency would need to actively obtain consents from all of the other involved agencies. Otherwise, if the agency is unable to obtain the consents, or time is not critical and that agency can wait the 30 days, then that agency would wait the 30 days, and if there were no objections, then that involved agency would at that time officially be the lead agency. If there is an objection to lead agency status, then there's a process in the regulations whereby the commissioner of the DEC will resolve any disputes. And so this is a process that I just discussed. The agency desiring to act as lead agency distributes Part 1 of the EAF to the involved agencies, requests consent. Typical involved agencies often include the DEC, the Department of Transportation, IDAs. If you're a school district, then SED is an involved agency, but they've issued guidance that has basically already transferred lead agency authority onto each of the specific school districts, so there's no need to obtain consent from SED before moving forward as a lead agency on a school district project. And so again, if there's no objection received within 30 days, then that agency is good to go as the lead agency. It is also typical, and it's a courtesy, to distribute the EAF to any interested agencies, including any federal agencies. Federal agencies are not subject to SEQRA. They'll undertake a separate but similar process under NEPA, the National Environmental Policy Act. And typically these letters also request comments from both the involved and interested agencies on the project. So the next step is probably the most significant step, and that's the determination of environmental significance. And that's the decision whether to require an EIS to further explore potential impacts of the proposed action, as well as options to avoid or mitigate the impacts. Okay, so I see a question. Actually, I see a couple of questions that have popped up here. So let me just pause here for a minute. So is there a requirement that an EAF submitted to an agency be correct, is one of the questions that I see that's popped up here. Well, yes, the entity that is completing the EAF is signing Part 1 of the EAF, and in signing that is basically attesting to the accuracy of the information in the EAF. If it turns out that there is incorrect information in the EAF, or if something about the project changes, and maybe something was true in Part 1 that is no longer an accurate statement, then the reviewing agency can always go back and ask the applicant to correct that information in the EAF. So certainly you want your Part 1 to be as accurate as possible before you move into the step of determining environmental significance. And then can I elaborate on the SED no need for consent for coordination, although they are a funding agency? Because SED has previously issued a guidance document that has basically said, we, SED, are not going to act as the lead agency in connection with any capital improvement projects sponsored by any individual school districts, and each of the individual school districts will be responsible for undertaking its own SEQRA review, and not only for undertaking its own SEQRA review, but also for undertaking any consultation that might be required with the New York State Office of Parks, Recreation, and Historic Preservation. So that's why there's no need to seek formal consent from SED if you're a school district moving forward with a capital improvement project, because basically SED has already said, not on us, it's on you. And then our departments involved agencies. Departments. So I guess I would answer that question by saying it kind of depends on what the department is. You know, the Department of Transportation is an involved agency. The Department of Environmental Conservation could be an involved agency. But other departments may not be. So if you're a municipality that has a planning department, not a planning board that makes decisions, but a planning department that advises the municipality or advises the board, then that department would not likely be an agency. So it has to be some type of entity that's responsible for issuing permits. So in some occasions, the department, yes, can be an involved agency. Other occasions, no, it would not be. And then one other question I see here, could you please explain again why a SUNY school may not have to go through SEQRA, even though the project may be funded internally, but indirectly may still be public money? Okay, so SUNY schools, if I misspoke, I apologize. SUNY schools are always subject to SEQRA because they're part of the SUNY system, and the SUNY system is considered a state agency. So if you are a SUNY school, you will have to go through the SEQRA process. If you are a private college or university and your project does not require any local municipal zoning land use approvals or any public funding, then that project by a private college or university may not be subject to SEQRA. So SUNY schools, you're going to have to go through SEQRA. Private schools, maybe, maybe not. Please review public hearing requirements for SEQRA. We'll get into that. I will be talking about that shortly. And then how long does the process take when it runs smoothly? I'll cover that when we get to the end of each of these sections. So I'll talk a little bit about that depending on whether you're going the neg deck or the pos deck route in a couple of slides here. So we'll move forward now with the determination of significance. I need to click back on the slide to advance it. All right, and you've heard me talk already about negative declarations and positive declarations, the neg deck and the pos deck for short. So the negative declaration involves the finding that the action will not have any significant adverse environmental impact and no further review is required. A positive declaration is a finding that the action may include the potential for at least one significant adverse environmental impact, requiring further study in an environmental impact statement. The lead agency is responsible for making the determination of significance after reviewing the environmental assessment form, together with any additional application materials, environmental studies, or input from other agencies. The lead agency will consider impacts identified in Part 2 of the EAF and then complete Part 3 as necessary. So Part 2 contains a list of different potential impacts that various projects may cause to occur. So it looks at not just the potential impacts, but what's their magnitude. Is the magnitude potentially small, or is the magnitude potentially moderate to large? And so Part 2, the responsibility to complete that is on the lead agency. And then for every impact in Part 2 that the lead agency believes is potential moderate to large, then it must analyze the importance of those potential moderate to large impacts in Part 3. So there has to be some type of discussion and written support as to the importance of those impacts identified as potentially moderate to large. And this is really the key. This is the key legal standard by which all determinations of significance are judged in a court of law when there's a challenge. And that's the hard look test. And the hard look test requires the lead agency to identify the relevant areas of environmental concern, to thoroughly analyze the concerns for significant adverse impacts, and document the determination showing why the environmental concerns that were identified and analyzed will not be significant. It's important to create an adequate record in order to support that decision in the event that the action is challenged. And so Part 2 of the EAF identifies the potential for adverse impacts to occur within each category of resources. So on the full environmental assessment form, there are 18 categories that range from air, surface water, groundwater, transportation, community character, community plans, historic resources, archaeological resources, agricultural land. So, and then under those larger categories, there are a number of smaller potential impacts that should be evaluated and assessed as to whether they will be potentially moderate to large or whether there will be small or no impact. If you're uncertain or if you think the answer is maybe, then you should check the box for potential moderate to large. So treat any maybes as a yes, it's potential moderate to large, there may be an impact. And then look at that in your Part 3, and then you can determine whether or not that impact is so significant that it requires further study, or maybe it's been mitigated by something in the project design so that it's not significant and doesn't require further evaluation. And so this is covering what we've talked about, right? You're estimating the probable magnitude of the impacts by comparing the elements of the proposed action to the examples and thresholds in the Part 2, whether it's small to moderate or large. Just because something's large, which is what I just talked about, does not also mean it's significant. It just means you need to look at it a little further in Part 3. You can still conclude that something's large but not significant. And then you're also going to consider any mitigating measures that are included in the project design, as I just discussed. Part 3 must be completed if there are one or more potentially moderate to large impacts identified in Part 2. And in the Part 3, you'll evaluate those potentially moderate to large impacts for magnitude and importance. That includes looking at the size, extent, the severity of the impact, looking at the probability, duration, reversibility of the impact. Will the effects of the impact be broad? Will they be more local? Is there local consistency of the project? And then, again, looking at any design features that will avoid or minimize those impacts. When you get around to reaching your ultimate determination of significance after completing Parts 2 and 3, and whether that's a POS-DEC or a neg-DEC, that determination must be in writing. And it should state whether each potential impact is likely to be significant, is likely not to be significant, maybe it's adverse but not significant, maybe it's significant but not adverse. Whatever your finding is, you have to elaborate on that in a writing that will then be published and filed and mailed to other interested agencies. Also in that written determination, you're going to describe any mitigation that you considered that was included in the project plans. You should reference any sources relied on to reach your conclusions and explain how those sources and studies support your conclusion. So in other words, you're going to show your hard look in your written determination of significance. Again, whether it's a POS-DEC or a neg-DEC, it's good to have that documentation. So if after going through all of the information in the record, all of the information in the environmental assessment form, all of the comments that you may have received from other interested or involved agencies, if after reviewing everything, the agency believes that the action will not have any adverse environmental impacts, or that the identified environmental impacts are not significant, then the lead agency may issue a negative declaration. An issuance of a negative declaration ends the SEQRA review, although there are still procedural requirements including publication and filing. And the negative declaration must contain a statement that it is a negative declaration, the name and address of the lead agency and the contact person, a description of the action, the seeker classification, the reasoning that supports the determination. And if that negative declaration is for a type 1 action, then it must be published in the Environmental Notice Bulletin and be filed with the Chief Executive Officer of the political subdivision in which the action is located, filed with the lead agency, filed with all involved agencies, mailed or sent to any person who has requested a copy, and if the action involves an applicant, shared with the applicant. A negative declaration for an unlisted action only needs to be filed with the lead agency. And so before we move on to the issuance of a positive declaration, so in terms of how long does the process take when it runs smoothly? So to get to this point, if you're getting to a negative declaration, and it runs smoothly, then typically you can get to a negative declaration in 6 weeks would be the shortest amount of time. More typical is 8 to 12 weeks. Just depends on how aggressive you want to be in your schedule, whether you can get your board to hold special meetings to the extent those are necessary to move the process along. So it can be done if you're getting to a neg deck and you don't have a lot of opposition in pretty short order. And I should know, because I'm just thinking about this now, so if you're a school district, depending on the nature of the project and what you need to go through, I mean, it may be possible to do this process all in one meeting. That's not typical, but again, depending on the type of project, whether or not there's any opposition or controversy, there are scenarios where a school board could declare itself lead agency, go through the forms, and then issue a negative declaration all in the same meeting. So a question just came in that's appropriate to address now. If you make a determination of no significance, can you reopen SEQRA if there are design changes or information comes to light that changes the circumstances that led to the neg deck? So the answer to that is it depends. If you issue a neg deck and then you proceed to issue all final approvals with respect to that project, then typically the answer would be no, you can't reopen SEQRA. However, if you have not issued all final approvals and new information comes in with respect to the project, then yes, the regulations actually require the lead agency to go back and assess that new information and determine whether the negative declaration is still valid or whether this new information somehow changes the result of that assessment and requires the negative declaration to be rescinded and a positive declaration to be issued. So say, for example, you're a municipality and you undertake the SEQRA review for a large development in your municipality and you issue a negative declaration, and then you move into the next phase, which is to start to review any site plan or special use permit applications that have been submitted. And during that site plan review process, new information comes to light, or the applicant decides they needed to change the project in some way, then yes, the municipality in that situation would go back and reconsider SEQR in light of those changes. In that same scenario, if the municipality issues a neg deck, moves forward to issue any site plans, any special permits, completes that process, and so all approvals have been issued, and then some new information comes to light, then no, the SEQR process is not reopened. The one caveat that I would put on that statement is if that new information somehow requires the applicant to come in and say, amend their site plan application, well, that's an approval that the agency then has to issue again. So in that situation, no, not all final approvals will have been issued, and then that would reopen SEQR, and the agency would have to consider that change on the previously issued negative declaration, make a determination with respect to that before ultimately making a decision on an amended site plan application. So hopefully that was clear enough. If not, ask the question again and I'll try and explain it a little clearer. So we'll turn to the positive declaration. So if during your review process you believe that the action includes the potential for at least one, and it only has to be one, significant adverse environmental impact that requires further review, then a positive declaration is required. It's a very low threshold. It's a may threshold. It's a potential threshold. So again, you're going to err on the side of if you think maybe, then answer yes and issue the positive declaration. Positive declaration, all that means is that the environmental review process is going to continue with the preparation of an environmental impact statement, and then the EIS analyzes the significant environmental impacts of a proposed action and how those impacts can be avoided or minimized. Step 6 is the scoping process. So scoping is an optional process. It's used to really determine the relevant environmental impacts to be addressed. The idea is that it makes an EIS more readable so that it only includes relevant information. Scoping is also used because it allows for public comment on the proposed topics to be covered by an EIS, and it kind of creates a formal outline for an EIS. So right now, scoping is not required, although that is one of the proposed changes, is to make scoping mandatory. So you don't need to go through it, although again, it's kind of like coordinating review. It's recommended, especially for large and controversial projects. It can be initiated by either the lead agency or the applicant, and again involves the participation of involved agencies and the public. Preparation of a draft environmental impact statement. The fundamental purpose of the EIS is to analyze the full range of potential significant adverse environmental impacts of the proposed action and identify alternatives or mitigation measures to avoid or minimize those impacts. The EIS can be prepared by the project sponsor, the applicant, or the lead agency. Typically, it is prepared by the project sponsor or the applicant. Typically, the applicant or the project sponsor retains a consultant to help prepare the EIS. So an EIS has certain minimum requirements in terms of what needs to be in that document. There needs to be a cover sheet, a table of contents, some type of executive summary providing an overview, a description of proposed action, the environmental setting, and then an analysis of all of the potential impacts, whether or not there's any mitigation, and an exploration of alternatives. Typically, also in an EIS, you're going to want to look at reasonably related short-term and long-term impacts, cumulative impacts, unavoidable impacts, any irreversible and irretrievable commitments of environmental resources that would be associated with the proposed action, and any growth-inducing aspects of the proposed action. And then there are timing requirements for an EIS review. Again, these can be extended by agreement with the applicant. Typically, the lead agency has 45 days to determine whether or not a draft environmental impact statement is complete for public review. If it's not, it sends it back to the applicant with a list of reasons why it's not adequate. And then when the draft is resubmitted, the lead agency has 30 days to review the resubmitted draft for completeness. Once an EIS, a draft EIS, is accepted as complete, then the lead agency must file a notice of completion, have it published in the environmental notice bulletin, and posted on a publicly accessible website. And that notice of completion is what starts the public comment period. And the public comment period has to be a minimum of 30 days. But the public comment period only needs to allow for written comments to be submitted. There's no requirement for a public hearing to be held under SEQRA. Whether or not to hold a public hearing is purely optional. If there's a lot of controversy with respect to the project, and typically holding a public hearing is a better thing to do because it demonstrates that the agency allowed for more public involvement in the process. You know, and it's kind of a feel-good thing in that, you know, you've let the public come in and have their say, even if all they're doing is, you know, screaming and hollering about how much they hate the project. So typically, depending on the nature of the project, we recommend holding a public hearing, and that public hearing can often be held in conjunction with another public hearing that the agency may have to hold anyway in connection with it, whatever the underlying approval it needs to issue is. And then after that public comment period ends, the next step is to prepare a final environmental impact statement that has to be prepared within 45 days after the close of any public hearing, or 60 days after the filing of the draft environmental impact statement. And that final environmental impact statement is going to include the draft environmental impact statement, any revisions to the DEIS, copies or a summary of all comments, and a response to those comments. Upon completion of the FEIS, the lead agency then prepares and files the notice of completion of the FEIS together with the FEIS. And at that point, the lead agency can prepare its findings statement, which provides a rationale for the agency's decision, considers the relevant environmental factors, weighs and balances those factors with social, economic, and other considerations, and then contains a certification regarding compliance with SEQRA. At that point, each involved agency can also prepare its own written finding statement, and that finding statement may disagree with conclusions reached by the lead agency. So there are two types of finding statements. A positive finding statement is that all environmental impacts are minimized, mitigated to the maximum extent practical, and the project may be approved. A negative finding statement is that the environmental impacts cannot be mitigated and the project may not be approved. The finding statement must be issued within 30 days after filing of the final EIS, but may not be issued until the public and other agencies have been provided with 10 calendar days to review and comment on that FEIS. So you have to wait at least 10 days from issuing your FEIS to make your finding statement. And then just moving quickly through some special issues, segmentation. SEQRA requires that the lead agency consider the whole action, and so proposals or parts of proposals that are related to each other must be looked at together. Segmentation is defined as the division of the environmental review of an action such that various activities or stages are addressed as though they were independent, unrelated activities. So there are two situations when segmentation occurs. It can be when the project sponsor splits the project into two or more smaller projects in an effort to avoid a more thorough environmental review, or when the activities occur at different times or different places. And segmentation is not favored, but it is not strictly prohibited. So there are limited circumstances where it may be permissible, and that is when information on future project phases is speculative, those future phases may not occur, or the future phases are functionally independent of the current phases. If you're an agency and you're going to segment review, you need to provide justification for the segmentation in your determination of significance and in any EIS. And you have to demonstrate that the segmented review will be no less protective of the environment. Okay, so going back, what happens when the lead and involved agencies disagree on the finding statement? Well, what would happen then is that would obviously impact the approvals that get issued for the project. So if the lead agency thinks that the project can go forward, the lead agency will then in all likelihood issue whatever its approvals are for the project. However, if the involved agency disagrees and issues a different finding statement with a different conclusion, then the applicant may be at risk of not getting whatever underlying approval it needs from that involved agency, and so it puts the project at risk if the agencies don't agree. And they're free not to agree. So it just then goes to whether or not all of the final approvals that are needed for the project to go forward will be issued. And this kind of ties in nicely to this next slide, which is there's been some recent case law on what happens when, and in this example, in the cases, it was when the lead agency issued a negative declaration, but then in reviewing its underlying approvals, found that there was some impact to the neighborhood that resulted in that agency not issuing its underlying permit. So for example, in MLB LLC versus Schmidt, there the applicant was seeking a 3-lot subdivision. The planning board issued a negative declaration finding no significant adverse impacts, but the planning board denied the approvals on the ground that the subdivision would exacerbate bad drainage conditions. So you might ask, well, they found that there were no significant adverse impacts, presumably with respect to drainage, when they issued the negative declaration, but here they are denying the subdivision on the grounds that it would exacerbate bad drainage conditions. There, the court found that the findings were not wholly inconsistent because the SEQRA determination was that there were no significant adverse impacts, but there could simply be adverse effects associated with drainage and flooding. So the difference is in the threshold of the review criteria. So the threshold for SEQRA review is significant adverse. And the threshold for issuing a subdivision or a site plan or a special permit or some other approval might be less than significant or adverse. And so in that situation, you could issue a neg deck and still deny that permit on environmental grounds. And similarly, that also happened in another case, Chadwick Gardens v. City of Newburgh ZBA. There, the court held that the ZBA properly denied a variance application because it would have an impact on the neighborhood. But in another case, SCI Funeral Services versus the Planning Board of the Town of Babylon, the court concluded that the site plan could not be denied on traffic grounds when the negative declaration found no impact with respect to traffic. So again, it depends on how you write your negative declaration, what specific findings you made for each impact, and then again also whether the standard of review associated with whatever that underlying approval or permit is, if that standard is less than significant and adverse. The exception to this would be involved agencies. They're not constrained by the lead agency's negative declaration, so they could deny their permits based on environmental grounds. And then this goes to the question that was asked. Involved agencies are also not constrained by the findings made by a lead agency in a SEQRA finding statement. They can independently review the application based on its own standards. The one thing to keep in mind with respect to that is that that agency is bound by the EIS record. They can't go out and gather new or additional information. And then I mentioned earlier type 2 actions. Once a type 2, always a type 2. And so that applies to type 2 actions that are also part of larger projects. There are judicial decisions that support this conclusion. So in this instance, it's okay to look at a type 2 action separately from and possibly in advance of the completion of the SEQRA review for the remainder of the project. And the courts have said that that's not segmentation or that it constitutes permissible segmentation. So let's say you're doing rehabilitation or replacement on one school building, but you're doing, a large expansion on another school building as part of the same capital improvement project. In that situation, you can pull out your type 2 action and call it type 2 action and just do your SEQRA review on the larger action. And then this is another interesting topic, and that's the timing of public hearings. This issue has come up a lot recently, in part because there's language in the regulations and there's language in some of the municipal town and village law statutes, specifically with respect to subdivision, that define when an application is complete and say that an application is not complete until a SEQRA determination has been made. And some of those statutes say that you can't hold a public hearing until your application is complete. So in those situations, it would be impermissible to hold a public hearing before issuing a negative declaration or a positive declaration on a project. I've always thought that, I understand why this is done, and it's done because subdivisions in particular and certain other approvals have a default approval period, whereby if the municipality fails to make a decision within a certain period of time after receiving a complete application, then that application is deemed approved. But you can't have an application deemed approved until your SEQRA process is complete. So that's why those statutes are designed that way, were adopted that way. But in my opinion, it defeats the entire purpose of SEQRA, which is to involve the public as early in the process as possible to say that you can't have a hearing on a site plan or a special permit or on some other approval that's not, tied to holding a hearing on a completed application before issuing the negative declaration, because you're basically cutting the public out of the SEQRA review process by reaching that conclusion. Nevertheless, it is what it is, so the best practice, what we advise our clients, is that open your hearing before issuing the negative declaration, let people come in, say what they want to say about SEQRA. Don't close the public hearing until after you issue your determination of significance. So you would keep the public hearing open over a couple of meetings, would be the best practice, and that would assure you would comply with any case law or any statutory or regulatory law about not holding a hearing until after your application is complete. And then quickly, enforcement. There is no enforcing agency. SEQRA is really enforced by the citizens who would be harmed by the action, and they challenge SEQRA determinations in the form of Article 78 proceedings. And then the judicial standard of review, it is very deferential to the agency. Substantive challenges is based on the hard look standard that we talked about. Procedural challenges look at strict compliances. And then just quickly moving through the proposed revisions. This is the final step in a series of SEQRA upgrades. As I mentioned, DEC revised the EAF forms. They came out with mapping and guidebooks. So this is kind of the final step in a four-step process to revise the regulations. There are proposed changes to the Type 1 list. They're looking at lowering the thresholds for residential subdivisions because they believe that they were initially set too high. And so this brings the review of large subdivisions more into conformance with current practice. And then there are also proposing to align the threshold for historic properties with other sensitive resources, and what that means is for unlisted actions that occur, in ag districts or that occur near public land, there's a threshold, there's a percentage threshold that the project has to exceed to come into a Type 1 action. Historic properties has always been, if the unlisted action is near or in a historic district or a historic property, then it automatically becomes Type 1, and they felt like that included too many small projects in the Type 1 category just because of proximity. So they're also establishing similar thresholds before an unlisted action near a historic resource becomes subject to the Type 1 requirements. And then there are a number of proposed changes to the Type 2 list. These were broadened because they wanted to encourage environmentally compatible development, attempt to encourage development on previously disturbed sites. They wanted to encourage green infrastructure projects and solar energy development. And they also really wanted to allow agencies to focus their time and resources on those projects that are more likely to have a significant adverse impact on the environment. So you'll see the list on the next two slides of various proposed additions to the Type 2 list. And then just to mention a couple of others that I did not include on the slide, but they're also proposing to have all lot line adjustments and area variances will be Type 2 as long as those variances do not result in any increases in density. They're adding a Type 2 item that confirms that the county recommendation pursuant to 239M or 239M are not subject to SEQRA, and also to confirm that foreclosure sales and disposition of land by public auction, those are also Type 2 because that process is mandated by state law. And then just changes to the EIS process. Again, I mentioned earlier that scoping, they're proposing to make scoping mandatory. They're going to add some language to clarify when a submitted draft EIS is adequate. Basically, it will involve using the final written scope to determine whether everything is in the EIS. They're changing some time periods, increasing the time periods to review a DEIS for adequacy, and increasing the time period to issue the FEIS after a DEIS is accepted. Finally, and it's not on the slide, but it's worth noting that with respect to fees, an applicant can request an estimate of fees that it will be required to pay for the agency in connection with that agency's undertaking of the SEQRA review, and it can also request invoices to review the time spent by an agency or an agency's consultant in reviewing the environmental impacts of a project. So that's really just a fairness issue. And so, you know, the DEC will publish notice of these revisions in the State Register and the Environmental Notice Bulletin. They'll put out a draft generic environmental impact statement. There'll be a 90-day public comment period. They'll hold a public hearing in Albany for anybody wishing to comment on those revisions. And so I know we went a little over, and I apologize. If anybody has any additional questions, we'll give you a few minutes to submit those now. We do have a couple of additional questions here. Oh, and I also wanted to get back to the question on timing. So timing, because I forgot to do it when we talked about the positive declaration. So a SEQRA process running smoothly with a positive declaration and the preparation of an EIS, you're really probably looking at a minimum of 6 months. And that's if everything runs smoothly start to finish. Shortest period of time would be 6 months. And longest period of time, I mean, I've seen these drag on a year or more in some cases. The question came in on going back to making changes on a Part 1 that have already been circulated to involved agencies. Are you required to recirculate that Part 1 or otherwise notified the involved agencies of the changes? Certainly that would be a good practice, but I would say that burden also falls on the applicant to the extent that they're applying for a permit or approval from that involved agency. They're going to want that involved agency to have the accurate information with respect to the project. So I don't know that I've seen any cases that have overturned a SEQRA review for failure to send an amended EAF to an involved agency. But if you're dealing with a very controversial project and you're expecting litigation, why create a cause of action? Err on the side of dotting all your I's 3 times, crossing all your T's twice, and send the revised EAF to all of the involved agencies. Should SEQRA review be completed before a planning board starts a special permit or site plan review? No, it can be completed in conjunction with, because certainly I think there would be overlapping issues that the planning board would want to consider, you know, with respect to consistency with community plans, consistency with community character. Those are both factors that I think a municipality is going to look at in connection with a special permit and its SEQRA review. You know, impact on traffic is something that a planning board is going to look at with respect to its SEQRA review and its site plan approval. So there's no need to complete the neg deck before starting the special permit or site plan review process. The issue is really just with the public hearing and whether or not you feel you need to have a complete application in hand before opening the public hearing. And again, I think the way around that would be to open the public hearing before making your determination of environmental significance. Keep it open for more than one meeting. Issue your neg deck if that's what you're going to do. Continue the public hearing, and then you can close the public hearing, and then you're in compliance. So those two processes can really go hand in hand. What you can't do is you can't issue a site plan approval or a special use permit until you've completed SEQRA. You can't give the final approvals, but you can start the process. If a municipality is not bonding for a public works project, is a seeker still required? Yes, because a municipality is taking an action. A municipality is undertaking a project. So in that case, if no other approvals are needed, right, because they're not bonding and they're going to be approving the project, then in that case the project sponsor would also be the lead agency, but it is incumbent on the municipality to undertake the environmental review process for that project. Understand that currently a municipality is to hold seeker when a land transfer takes place pursuant to an in rem tax foreclosure process. Well, right now it's not specifically listed as a type 2 action. I, however, have advised clients that I do not believe that process is subject to seeker, because I have always felt that it falls under, or that you could make an argument that it falls under other type 2 categories, and that there was, you know, or that I would say that there's no discretion in a tax foreclosure. It's mandated by state law, and so since it's not a discretionary approval, then it's not subject to seeker. So I think including it on the type 2 list clarifies the practice that people have been engaging in all along, quite rightfully. So, you know, just because it's not on the type 2 list doesn't mean that it's subject to seeker. I think there are other valid justifications why it is not. Special licensing required to perform an EIS? Nope, anybody can do it. So if you think you have a pretty simple project and you only have one potential impact, and you as the lead agency or as a project sponsor think you're qualified to prepare that EIS on your own, as long as it includes everything that the regulations say it needs to include, you can prepare that document yourself. So it is not necessary to have any kind of license. It is not necessary to have an engineer prepare that document. Does acceptance of a donation of land to a municipality require a seeker before action is taken? That's an interesting question. So I would say that unless and until the type 2 list is amended, that a donation of land, since it is an acquisition of land, and all acquisitions of land are subject to seeker, it's just a matter of whether it's unlisted or type 1, that a donation of land is subject to seeker. If the proposed revisions go through, then the changes that they are proposing will allow some dedications of land to a municipality to be identified as a type 2 action and not subject to further environmental review. But until those changes are in place, then yes, a dedication of land to a municipality would be subject to seeker. And I think that is all of the questions that we have. And I thank everybody for listening. I appreciate everybody's time. I apologize for going over, but we had a lot of good questions, led to a lot of good discussion and other thoughts to throw out there. So again, I thank you. If you do have any additional questions, feel free to email me. My email is kbennett@bsk.com.